a gentleman known as Headucator. He can be charged on the basis of the video of male and male intercourse. But aside from that video that came out, that individual holds himself out and promotes homosexual activity on his social media page. That person is holding himself out, so there is an act, and there is the actus rules and mens rea can be determined from his activity. There's a particular person on social media who is constantly dressing up and holding himself out, a man as a woman, and is being even celebrated at public functions. Such a person can be charged under this law if he passes out for holding out as a lesbian. A week before my appointment by the president, there had been an engagement between the president and the Catholic Bishops' Conference, where the president had indicated that there was a possibility of the state taking over the bill and having it introduced by the Attorney General. Subsequent to that, I was appointed minister, and then at my vetting, I was asked that question. I made a commitment to the country at my vetting that despite the intention expressed by His Excellency the President, and without prejudice to his mandate and authority, as Member of Parliament for the people of Ningo Pram Pram, one of the reasons my chiefs and people had returned me to the 9th Parliament was because they thought I had unfinished business from the 8th Parliament, which was the passage of this bill. And so I indicated that I was going to reintroduce the bill even as a 7th minister if I was approved by Parliament. Working with my co-sponsors, we reintroduced this bill before Parliament. And Chair, I would align myself with the submissions of your available ranking, which is to the effect that the provisions in this bill were masticated by parliamentary committees and plenary for over 2.5 years. We went through the mill to pass this bill. The bill was passed coincidentally on our Republic Day. On the anniversary of the Crossroads shootings in February, which is I think 28th February. On the 28th of February 2024, that was the day Parliament unanimously, without any exceptions, passed this bill. And I remember that day granting an interview to say that the issues or incidents of 28 February 1944 led and spiraled to the independence of Ghana, and that the passage of this bill was going to spark a certain movement across the African continent for the protection of family values. Chairman, since Ghana started working on our bill, since we introduced this bill in 2021, Uganda has replicated our bill, gone ahead to pass it. Senegal has done the same, passed it, and even reviewed their bill to increase the sanctions. And let us be clear, it has not brought any economic sanctions on any of those countries. And so it is important that I believe that we have done this, but we will respect the processes. The processes for the passage of a private member's bill must be respected to the latter through every single phase. So even though we want expediency, I will urge that we do what the letter of the law says is the process. Given the experience of 2024, where the bill suffered 3 court suits, not one. There were 3 suits against this bill. But because of the rigorous nature that we went through and Parliament did its job right, the bill survived all 3 suits. We do not want a situation where tomorrow, after we pass it, somebody goes to court on procedural grounds to say that a committee or Parliament skipped a ground. But let us carry out the procedures expeditiously. Mr. Chairman, I would not belabor the issues of why the bill is before this Parliament again. That has been expressly stated here. But let us be clear. And because the media is here, I have heard people who have said, Sam George, and his colleague sponsors have abandoned. We've run away because I've been appointed minister. Chair, the process is the process. And I'm grateful to my co-sponsor, Honorable Ntim Fordjour, who had cause to go on national media and say that that is not the case. He's worked with me, and I appreciate his candor on that matter. But let us also be clear, there is no bill before President Mahama today. And so the calls from very respectable groups like the Catholic Bishops' Conference are very well placed because of how sensitive and important this is. From the office of the Chief Imam, very important calls have been made. We've been told by the Chief Imam spokesperson that the Chief Imam's pleasure is to see this bill passed before he is called to his maker. I believe that Parliament has a responsibility to grant the Chief Imam his wish and grant the Catholic bishops their wish by making sure we do what we have to do expeditiously and placing this before President Mahama. And then we can collectively demand that President Mahama signs the bill. I have all the assurances that he will do the necessary when we place the bill before him. So, Chairman, I thank you. And once again, let me reiterate the fact that as for the clauses, we have gone through them, we've masticated them, we will go through them expeditiously, and there is nothing new. I have seen a few suggestions that have come. We can look at the merits or demerits, but the body of the law, Mr. Chairman, remains the same. I thank you.
Thank you so very much. As far as the 9th Parliament is concerned, this is a completely new bill. And as far as I remain chairman of the Committee of Constitutional and Legal Affairs, this is a new bill, and we'll treat it as such. Thank you so much. Honorable Ntim Fordjour.
Thank you very much, Honorable Chair. I'm indeed very grateful to your good self, the leadership of the Constitutional, Legal and Parliamentary Affairs Committee, and the leadership of the Human Rights Committee. We also recognize our colleague members of Parliament and the co-sponsors, as well as the eminent members of the public and CSOs who are very interested in this very matter, and the media. In fact, this is a bill which object is to ensure the proper sexual human rights and family values within our society are entrenched. It strikes at the very core of our morality, of our culture, of our tradition, of our custom, and what defines us as Ghanaians. A consensus has also been reached across all faiths within this country, whether Muslim, Christian, traditional, and any other faith for that matter, who have all so in a very sacred manner upheld that the practices of LGBTQA+, P++, are repugnant, very highly repugnant to our values as a nation. And therefore, recognizing that a family in our context as Ghanaians and within the remit of our constitution emanates from a family unit, a unit comprising of a male and a female contracting marriage, and that marriage procreating children, and then other children and grandchildren, great-grandchildren, coming out of that, and that unit relating with society, with its attendant expressions of sexual desires. That is what consensus has been reached. Over the past years, we have seen pressures upon pressures upon our government. Successive presidents have not escaped these pressures, obviously coming from globalization, coming from acculturation, and the fact that some foreign cultures want to force their highly abominable acts sexually down the throats of Ghanaians who cherish our values on family and related sexual orientations. And so we have had, as far back as President John Ejekun Kufuor, having the occasion to state clearly on very important platforms, reasserting his position and stance against succumbing to any pressures from the West or any external partners for that matter in legitimizing same-sex relations and marriages. In fact, the President John Ejekun-Kufuor utterly rejected those pressures. Then we come to President, His Excellency, the late Professor John Evans Atta Mills, may he so rest in peace, who also had the boldness to look at the Prime Minister of Britain in the face, Prime Minister David Cameron, and told him that he disagrees with his position. He is entitled to his expressing a position that is reflective of the culture of his people, but as President of Ghana, he, President John Evans Atta Mills, would not in any way succumb to any pressure coming from any quarters. Even if it has to come with aid, the aid will be rejected, so that the sanctity of our culture is upheld. Of course, President Nana Addo Dankwa Akufo-Addo on many occasions also had the opportunity to assert his position. And one notable such occasion was in a ceremony held by the Anglican Church, the Anglican Diocese, West Africa, where he stated that under his watch, same-sex marriage would never be condoned and would never be entertained. So all these successive public record pronouncements had been made. However, we all also recall that the heightening pressure on our society by certain external forces, covertly and overtly, trying to infiltrate these LGBT and all its variations into our society was palpable, and particularly so as the only string of law that protected our society from such infiltrations, as ably quoted by the Vice Chairman of the Constitutional Legal Committee, Honorable Lawyer Enu, was Section 104 of Article Article 29, where unnatural carnal knowledge is the only strength, and that is obviously 1960. Between then and now, we've seen various variations fluidly manifesting, giving rise to pervasive, absurd variations of sexual absurdities. And therefore, there's a need to introduce a law which more comprehensively will be able to address the changing dynamics of such sexual matters. And that brought us to consensus in February, in 2021, where myself, my respected colleague, Honorable Sam George, and a group of 6 other colleagues, including Honorable Bedra, Honorable De La Soa, and the rest, Honorable Helen Tonso, we co-signed a bill, Human Sexual Rights and Family Values Bill. And that bill, in fact, in the past 10 years, as a matter of public record, received more public interest than any other bill that I'm aware of in my 3 terms in Parliament. In fact, there was serious interest, massive, overwhelming interest from faith-based organizations, from the Office of the Chief Imam, from the Coalition of Muslim associations, from Christian Council of Ghana, from Ghana Pentecostal Charismatic Council, from Catholic Bishop Conference, from all walks of faith, and from the House of Chiefs, our traditional authorities. We had overwhelming interest from CSOs, notable among them Coalition for the Proper Human Sexual Rights and Family Values, and other groups, including even groups who had dissenting views. But all these views came up for considerations and, of course, were swallowed up legitimately in the overwhelming majority of views. At the time, an empirical survey conducted by CDD Ghana, which outcome is very much relevant even as of today, posited that in Ghana, 93% of our population, overwhelming percentage, consider the practices of LGBTQ and all such absurd variations highly repugnant to our laws. Now, the bill was passed. When it was passed, there were many challenges that was faced. Thankfully, by the latter part of December 2024, the matter terminated at the Supreme Court. And I have in my hand the full judgment passed on that bill. So the matter was settled. And in December 24th December 2024, I have in my hand the bill, the final version of the bill, after the Supreme Court pronouncement, which had been signed by the clerk to Parliament. Unfortunately, the bill could not be assented to. The 8th Parliament expired. So in the 9th Parliament, on February 21st, a group of 10 colleagues, including Honorable Sam George, Honorable Bedra, Honorable Hassan Tampuli, Honorable Anthony Mier, and a number of our friends came together and presented the same bill, word for word, clause for clause, with nothing omitted. Substantially, same bill was presented through the private members' procedure. I must put on record that since then, the procedure, according to our standing orders in the handling of a bill introduced through the private members' motion, has been, all those processes have been meticulously followed. When we even had cause to meet the private members' committee chaired by the First Deputy Speaker, Right Honorable Ahiafo, he indicated that his checks reviewed and he asked for confirmation, and we affirmed that indeed it is the same bill reintroduced, same bill that had been passed through all the various stages and scrutiny by the 8th Parliament. Parliament may be different, but substantially same Parliament. Within just a space of few months, the same bill had been reintroduced, and for which he ruled that no further scrutiny had, the bill didn't have to be subjected to further scrutiny, and without hesitation, with alacrity, I must indicate, approved that a bill qualifies to be passed as a private member's bill, and added a recommendation to the Speaker with the note that it's the same bill which should not be delayed and which should not be subjected to fresh consultations and attempt to build a fresh, consensus. The bill was also ably supported by a fiscal impact analysis conducted by the relevant section of Parliament, which passed the bill as eligible to be passed as private members' bill. All these considerations gave rise to its gazetting on October 2025, September 2025, 10 September 2025. Upon the gazetting, it was quite surprising that when it appeared on the order paper in Parliament the next day, it was deleted conspicuously. This gave rise to a lot of public concerns. We had to wage a number of advocacies and pressures before 7 months later, the bill found expression and was listed again on the order paper, which first reading was done and consequently referred to the Constitutional Legal Committee. And about 3 months now, we are excited that we have the opportunity to meet the committee to consider this. We must also add that the recent pronouncement by the President, which was amplified by the government spokesperson, Kwachu Fosu, on the priority of LGBT matters, gave rise to a lot of concern from the public. CSOs, traditional authorities, faith-based organizations, and many among them stated their public, positions on the seeming, changes and softening in stance. But we at this stage will not preempt or impugn the integrity of any leader and proceed on the assumption of the promise given by the President that when this bill is passed, he will sign. I do not think that this bill should be subjected to fresh national dialogue. In fact, all the CSOs and all the concerns most of them have gone through are the same concerns that came up in the first cycle of this bill. The same, all the CSOs who have come today are the same CSOs and stakeholders who participated. And so there is no reinventing the wheel. There's really nothing broken in this bill to be fixed, and for which it should be expedited. And in expediting, we are not also indicating that certain shortcuts should be entertained. We can expedite this bill in a day without compromising any part of our procedures, so long as our standing orders are concerned and so long as the Constitution of Ghana are concerned. And therefore, we would appeal to the leadership that in your magnanimity and in line with the overwhelming concerns of the public who are eagerly waiting for the same bill to be passed, considering that the plethora of legal challenges and battles which delayed its passage and assent, having survived that and terminated the apex court, we don't need to, knowingly or unknowingly introduce new additions and elements that will further make it vulnerable and prone to challenges that will culminate in another obstacle. We want to see this bill passed and assented to as soon as possible, and we will crave the indulgence of the leadership that we adopt. And in conclusion, Mr. Chairman, we crave the indulgence of the chairman that we adopt the bill in the shape and form as it is, having survived very lengthy, legislative process already, and then a report filed, and then we take it for second reading, and then consequently third reading.
Thank you.
All in the same day. I thank you very much.
Thank you, Reverend. Once again, let me put on record that the bill my committee is seized with is a brand new bill. Every single word, letter, paragraph is brand new. And that bill will pass through the normal process of processing bills. We don't recognize that this bill had come through before. As far as the committee is concerned, it's a brand new bill, and we'll treat it as such. So we'll go straight and still take memoranda, we'll take concerns from individuals, we'll take concerns from the public, and even the Constitution of Ghana is subject to review today. And so even if this bill was passed and there's a need to go over it again, we will still go and do amendments. Rev, rest assured that we will go through this bill expeditiously and get it sorted out. Again, Parliament is different from executive. Mr. President's pronouncements have nothing to do with parliamentary procedure. So for us, we're working in accordance with parliamentary procedure, and we'll go through that.
In fact, before the break, one of our Queen Mothers raised an issue about intersex. And so I did engagement with the CSO called Keywatch Ghana and Intersex Ghana as well, to have a conversation around what the intent was. Chairman, when this bill was first introduced in August 2021, intersex was one of the categories that were criminalized. During our public hearings, presentations were made by civil society organizations and medical doctors that indicated that the intersex community did not see themselves as part of the LGBTQ group, and that the intersex community are completely distinct because in their case, theirs are situations of biological effect and not a personal decision as you see in the other categories. And so we did subsequent amendments to use and introduce an exception clause everywhere criminalization was done or a listing was done to accept the intersex community, just so that we have omnibus provisions that, for example, if you read clause 1A IX, yes, even before we go there, 1A IX, after we had listed all the people who the act applies to, we say a person of any other sexual orientation or in a relationship that is contrary to the socio-cultural relationship between a male and female. Because of the prospective nature of the legislation, we knew that we could not have exhaustively listed all the categories, so we did that omnibus provision. But the fear there then became that tomorrow, after this bill becomes law, a judge in interpreting this omnibus provision may add intersex. And so we then in C brought in an exception, which says that except where the procedure is intended to correct a biological abnormality, including intersex, Now, a further issue has been raised that there is a societal stigma around intersex persons. And if we keep the phraseology in the bill today of biological abnormality, it lends credence to the fact that intersex people have a biological abnormality, which entrenches a certain stigma. I have worked with them and looked at the proposal they have brought. So this is their proposal. And why I want us to do this in 1C, is that if we do this, then I'll request that, Chairman, it becomes consequential across the entire bill. 1C reads today, who provides or participates in the provision of sex or gender reassignment, surgical procedure, or any other procedure intended to create a sexual category other than the sexual category of a person determined at birth, except where the procedure is intended to correct a biological abnormality, including intersex. Chair, they have proposed that we delete except where the procedure is intended to correct a biological abnormality, including intersex, and replace with where the procedure is medically necessary. So
Are you doing except where?
No. So it is now. It is going to read who provides or participates in the provision of sex or gender reassignment, surgical procedure, or any other procedure intended to create a sexual category other than the sexual category of a person determined at birth, except where the procedure is medically. So you now begin to delete. You delete from intended. So it is medically necessary to address innate variations. Medically necessary to address innate variations in sex characteristics, including intersex. So we replace biological abnormality with innate variations in sex characteristics. Then they continue with additional suggestions, which I have told them we are opposed to, and they've agreed. The complete rendition would have been to continue beyond intersex to say carried out in accordance with current medical standards and with the full, free, and informed consent of the individual informed, or in the case of a minor, in compliance with law. And we've said that for us, our opposition to that is you then move consent, the right of consent, to a minor, which again becomes a question of legality. And these provisions do not deal with the issue of consent. It deals with accepting intersex persons. So, Chair, it will then read, C will then read, who provides or participates in the provision of sex or gender reassignment, surgical procedure, or any other procedure intended to create a sexual category other than the sexual category of a person determined at birth, except where the procedure is medically necessary to address innate variations in sex characteristics, including intersex. And Chair, if this finds favor with the entire committee, it would then be a consequential amendment across the entire bill. Wherever the exception clause for intersex appears, we will introduce this new phrase to replace just the biological abnormality, so that the bill is not seen to enforce a certain stereotyping and stigma in society. Respectfully submitted, Chair.
Thank you so much. So, I mean, before we even proceed on this, we had some meetings with the Human Rights Committee on this bill, and most of these issues were trashed out, same as we are just reading. They've even been refined. So we are going to post what we have on our general platform, the issues that we had raised. It was clear at that meeting that biological abnormality is a stereotyping word. And so we didn't find any other, apart from intersex. What other biological abnormality would you anticipate? And so, on that note, we decided at that meeting that C will read, and it will have consequential amendments wherever we have biological abnormality, which is a stereotyping word. C will read, who provides or participates in the provision of sex or gender reassignment, surgical procedure, or any other procedure intended to create a sexual category other than the sexual category of a person determined at birth, except in the case of intersex. And it ends there. Yes.
Chair, there's no need to litigate this.
Absolutely.
What the concern was the use of the phraseology biological abnormality.
So we are
can
ending
exempt
at
that.
except in the case of intersect, which is what we wanted to take away that biological abnormality.
Yeah, we're aligned with that.
Yeah.
I mean, it speaks to the spirit of what Key Watch Ghana has also presented.
Absolutely. So, and it doesn't whittle down anything. It still carries the same meaning. And then we rather are taking away that stereotyping word, biological abnormality.
What will be the rendition now?
So the rendition says, C, who provides or participates in the provision of sex or gender reassignment, surgical procedure, or any other procedure intended to create a sexual category other than the sexual category of a person determined at birth, except in the case of intersex. It ends there, and it carries the same meaning. It takes away the stereotyping and the rest of that, and we will have consequential amendments wherever we find biological abnormality. I think we're good to go on this. Yeah.
Yes, I agree.
Any on one? We move to two.
For avoidance of doubt, this bill, in the previous and in the present, it is not seeking to target intersex.
Yeah.
It is not seeking to deny intersex any marital privileges or sexual privileges.
Yeah.
And that is why we also recognize the special categorization and the interventions that medically necessary.
The reason we are exempting them
at various stages. The reason we are exempted. So they are exempted. The contention we are giving here is my argument was to further even enhance the removal of stereotypes, so that people do not see intersex people as attaching stigma. Absolutely, because their sex is determined at birth, and then as they go on at various stages, certain interventions medically are necessary to reinforce that gender.
Okay, that's fine. Let's move on. What would you define as a non-binary as part of your 3EIX? Yes.
It's been defined in 18.
Yes.
Non-binary means a sex categorization other than male or female. Because there are people who today in the LGBTQ community hold out not as a he or a she, but as an it or as a they. Some people recognize themselves as objects. They don't want to be categorized. Binary definition of gender is male and female. There are people who say that they are neither male nor female. And so we are holding those people, we are prohibiting such expressions in Ghana. So that's what we mean by non-binary.
V-I-I-I, an ally.
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 An ally are those who...
An ally. does that include a health worker?
So
read your definition.
Yes. Yeah. So an ally is defined as a person who produces, procures, markets, broadcasts, disseminates, publishes, or distributes a material with intent to promote an act prohibited under this act. B, evoke the interest of a child in an act prohibited under this act. Or C, teach a child to explore a gender other than the binary category of male or female. So, for example, if you have a health worker who is actively prescribing testosterone to a woman to help her transition that person is carrying out an act that is promoting an act prohibited under this bill. So, or a teacher who is teaching children that it is okay for a boy to fall in love with another boy or a girl, that person is considered an ally. Allies are largely heterosexual people who themselves are not engaged in any LGBTQ, but promote the activities for in many instances financial gain. So many of the rights groups in Ghana are led by heterosexuals who are busy pushing that we must recognize homosexual rights, meanwhile they are heterosexual and claiming that it is human rights. So allies are a category of persons who themselves may not be practitioners of any of the prohibited acts here, but are promoters and encouragers and facilitators of the acts we are prohibiting. That's the most.
They are abettors.
Yes. A person may hold himself out or may be held out. Now, the danger is that a person may be held out as a lesbian or gay, and the person is not.
Yes.
But in this case, it's the positive acts of the person.
That's the person holding out.
This is the person who is holding himself out. I am gay. Positive manifestation and saying to the whole world that I am gay. So if you don't leave it this way and you leave it to the good or bad judgment of people to hold people out, you may be holding out the wrong person.
At what point would you be charging that person? Is it when he tries to hold himself out, or when you think that he is?
All right. So beyond, you see, holding out in itself is a manifestation which is against the law, number one, and committing an act pursuant to the holding out is also another offense.
Mr. Annan,
So if you are being charged, Mr. Chairman, let me just learn. So the person may be charged on 2 counts: 1 for holding out, and 2 for engaging in an act which is also pursuant to it. You see the point I'm
that's
making?
fine.
So let's.
Just to support him, Chairman, currently,
Yep.
one of the biggest challenges we have is people who are on social media holding themselves out as 1 or 2 of these expressions and publicly doing manifestations. The law is saying that, and with holding themselves out in that mannerism, are actually encouraging and influencing people on social media to embrace that. We must be able to hold such individuals responsible for that public expression. That is separate from when you find somebody in the act. And that's where I agree with Honorable Tampuli, that this will create 2 different charges. One of holding out. So I don't want to mention a particular name, but there's a particular person on social media who is constantly dressing up and holding himself out, a man as a woman, and is being even celebrated at public functions. Such a person can be charged under this law if he passes out for holding out as a lesbian.
So that's good.
Honorable.
Dr. Annan.
I think if we don't take care, we make things look so broad, and this law must also meet the criminal test. I mean, the principle of criminality and what amounts to criminal culpability. The 2 must go together. The Artus rules and the mens rea. So if I say I'm an armed robber, or I believe in promotion of armed robbery, does that amount to criminal liability? And if you don't take care, this will leave room for people to stigmatize and speculate.
Yep.
So it's very dangerous to say holding out. Holding out means that I can hold.
No, that's not what the bill is saying. The bill says a person shall not hold out. So you do not hold me. I hold myself out.
Not holding you. Holding you can be your dress, your appearance, the way you the gesture.
All right, so let me explain.
Chairman,
let me explain and make
this is Parliament. In Ghana today, there is a gentleman whose video has been, there's a gentleman for whom a video was leaked and an altercation between himself and a male lover of him came up last year. A gentleman known as Headucator. Now, he can be charged on the basis of the video of male and male intercourse. That is a different thing. But aside from that video that came out, that individual holds himself out and promotes homosexual activity on his social media page. That person is holding himself out. So there is an act, and there is the actus rules and mens rea can be determined from his activity. So you take his activity on social media, his public commentary he has made where he admits to what his sexual preferences are.
So you can't make that statement.
So
he's not allowed to make that statement.
It is not just about making the statement. That the actus rules then goes to what has he been doing. The statement is an evidence of the mens rea, the thinking. But the actus rules is in what has he done to actualize the statement that he is this.
So
then
those two, so those two must go before you can ground a cause of criminality. So take for instance the example Dr. Anand gave. I am an armed robber. I hold myself out.
Yes. Tomorrow I'm going to rob.
Yes. Or no.
Yes. No.
Yes. So if it says
it's not enough to say you are a murderer.
That's right.
I killed this person.
That's right.
But you must show that you killed the person.
That is a reason you must not say holding out.
Fine. But you see, offenses are not the same. All right. This particular offense that we are doing, it is not like any traditional offense that we have known.
Hold out.
No, please,
hold out.
please.
That's what
And we are saying that holding out as a murderer will not encourage people to become murderers.